who makes our clothing? And who are the people and the process responsible for the whole manufacturing of our clothing? If you want to know more about this, Indira Gandhi National Open University from the School of Continuing Education has launched a program which is Certificate in Apparel Merchandising. There are many benefits after doing this program. You can become a designer in various fields. It can be fashion designer, apparel designer, costume designer, or even a textile designer. One can also work as a fashion consultant. Research and development is another field which one can take up after doing this certificate course. Going into academics is another perk after doing this program. Getting into fashion houses or fashion studios as an intern is also a very good option post doing the certificate in apparel merchandising. The basic eligibility of the program is 10+2. The duration of the program is 6 months to 2 years. The program is also available for both the admission cycles, which is July and January. The exams are conducted twice a year, in June and December. So what are you waiting for? Join this program and get an enriching knowledge in the field of apparel merchandising. And to do so, you can log on to the official website of the university, www.ignou.ac.in.
Achha. Hello and welcome to this program of School of Law. Today's topic is a part of our Diploma in Paralegal program. This program is offered by School of Law, and it is offered in English and Hindi medium. It's a 1-year duration program. And in this program, we have covered the main branches of law and only basic things, basic concepts, so that any person who is interested in studying law and who don't want to pursue law as career, but want to have some understanding about law, those people can enroll in the program. So today's topic is related is law of business enterprises. So there are various modes of doing business. You must be knowing some of them. Suppose you start a business, you open a shop, or you start a manufacturing unit, a factory, or something like that. Then the main consideration is the control of the unit, who will manage or control the unit or enterprise, and the liabilities of the people who own the enterprise. So there are a number of modes of doing business. One of them is sole proprietorship. This is the simplest form of doing business. One person opens a shop and he is the owner of that shop. Then it is an example of sole proprietorship. One person is the owner or the proprietor of the concern. There can be other people who are assisting or helping or participating in various capacities in the business, but the ownership lies with one person. So this is one of the form of doing business. It is suited for small types of business where where the investment is not much. The business which can be started with small amount of money. Another form of doing business is partnership. Partnership can be the minimum number of persons are 2 in a partnership, and it can be n number of people who can be the partner of a business. Suppose you must have seen the shops or other establishment where 2 people are doing business. 2 people are the 2 or 3 or 4 people may be the owner of that business. So it is a partnership. Now in 2009 the act came into force, which is called the Limited Liability Partnership. Actually, in sole proprietorship and partnership, the liability is unlimited. You are liable for any debt or liability of the firm or the sole proprietorship. But in limited liability, this concept was introduced in the modern business system, in the modern trade system, to limit the liability of a person to the extent of share. Suppose I have a share of say 100 rupees of a company or a limited liability partnership. Then my liability is limited to 100 rupees only, even if the company incurs the debt of thousands of rupees. But since I have the share of 100 rupees, I am liable for 100 rupees only. At best, my shares can be forfeited, but nothing more than that. But in sole proprietorship or partnership, the liability is unlimited. Your property which is not involved in the business can be used for paying the debt of the firm or a proprietary concern. But in limited liability, the liability is limited to the extent of the share or the amount which the person has invested in a firm. So this concept was introduced for the first time in 2009. And the act is called the Limited Liability Partnership Act, LLP. So this is one of the difference between a company and a limited liability partnership is that in limited liability partnership there are lesser kind of regulatory requirements, and there is less cumbersome process for starting a limited liability partnership or winding up or dissolving the partnership. Company is another form of doing business. This is suited to a large kind of business where the large amount, sizable capital investment is required. So in that type of business, the company is a very suited kind of mode of doing business. Sole proprietorship, I have explained. This type may be appropriate when the area of operation is small and the requirement of fund is such as which can be easily met by raising, which can easily be raised from the resources of a single person. The greatest drawback of this form is that in sole trader will be personally liable to pay all the debts and liabilities of the business. When it becomes difficult to run the business. So this is, as I told you, is a simpler kind of business, but the disadvantage is that a person is personally liable. In simple terms, a partnership is nothing more than the relationship between persons who have agreed to share the profit of a business carried on by all or any one of them. Actually, the purpose of the partnership is to share the profit. It is important to note that a partnership firm is not a legal entity, but only consists of individual partners for the time being. It is not a distinct legal entity from partners. Legal entity, actually, we will see later that the company has a separate legal entity from their shareholders, but that is not the case with the partnership firm. A partnership agreement can be either oral or written. So oral partnership can also be done, but it is preferred that a kind of a written agreement is entered into by the parties. However, an agreement in writing is necessary in order to get the partnership firm registered. Similarly, a written agreement is required if the firm wants to be assessed as a partnership firm under the income tax. So there are certain requirements when you want to be assessed or you want to register as a partnership firm. But oral partnership can be done, can also be done. The disadvantage of partnership is that the unlimited liability of a partners. So as I told you earlier, that the liability of the partners are unlimited. It is not limited to the share, and one partner can bind the other partners also in case of the liability of the firm. So this is suited for a smaller type of business where less amount of money is required, and it's a simpler form of doing business. Not much statutory requirements, regulatory requirements. Only requirement is registration, but that is also not a mandatory requirement. So small type of business where actually the partnership is based on the trust of the parties. Now partnership firms exist in retail business, small types of business. This partnership are suited for this kind of business. Now limited liability partnership LLP is as I told you, it was the Act of Parliament which gave recognition to this kind of partnership. Sorry, it's Act of 2008, not 2009. In 2008, the limited liability partnership was introduced. The main disadvantage of this partnership and a limited liability partnership is that in future, the limited liability partnership is a preferred type of business because as compared to partnership, because in limited liability partnership, the liabilities of the partners are limited to the shares, limited to the money which they have invested in the partnership firm. The main features of this limited liability partnership is that it has to be the main characteristics is that it has to be registered under the Act. So limited liability, it is necessary that for the limited liability partnership firm that it applies for registration. It then becomes a distinct legal entity and has a perpetual succession. Perpetual succession means that the firm continues even after the death of the partners in the same manner as companies, which we will see in later. So the limited liability partnership is a new form of doing a business where the liabilities of the partner is limited. Now, the another form of doing business which is very common in modern time is the company, and sorry, some more points about the like company. It needs to have a registered office, gets its name approved by filing particulars of partnership. So registration is necessary for a limited partnership, as I have told you earlier. Now, with regard to company, company has a limit. There are certain requirements. Company first, the company in simple terms is a group of people. The person can be natural persons or legal persons. Legal persons, for example, two companies can form a company, a third company. So whether natural or legal person, the limited, the company, when the people entered into a kind of agreement, and the company, when the has to be registered under the Companies Act 2013. Earlier it was to 1957, and 1957 Act was replaced in 2013. So and there should be a lawful business and a lawful object. The company should not engage itself in unlawful business, and the purpose is to do business, and the companies there are certain advantages of company over the partnership or sole proprietorship. Firstly, the company has a separate legal entity. Separate legal entity means, in simple terms, we can say company is a different person. I mean, let me explain with an example. A person can file a suit against a company. So the company will be liable. But in partnership or sole proprietorship, the partners will be personally liable. And even I can give loan to a company even if I am the shareholder of the company. There was a Solomon doctrine. There was a case named Solomon and Solomon in House of Lords, where it was a kind of family business, and the people gave loan to the company, they were the owners of the company. They were the shareholders of the company. So in real terms, nothing was given, nothing was taken. But the court held that the company is a distinct person, and the shareholders of the company, who were the family members who owned the company, are distinct, and they are liable to the extent of the share which they hold of the company. So the creditors can recover only that amount which the person is liable, as the amount to that amount which was the person has made himself liable by acquiring a share of the company. So legal entity, perpetual succession, legal entity, separate entity from its shareholders, perpetual succession. Company does not dissolve by the death of its shareholders. It continues. New shareholders may replace it, or the shares can be on the death of the person, the successor of that person are the shareholders. Shares are transferred by succession, whether it is testamentary or intestate, and shareholders can be changed. Suppose I sell the share of the company to another person, then that person becomes the shareholder of the company, owner of the company, to the extent of the share which he holds. So it's had a separate property, company's property, company's office, company's factory. It's a separate, it's not the property of the shareholders. Common seal, separate management. The management and ownership can be different, and in large companies, in big companies, it is generally different. Management are professional managers. So now there are various types of companies. I will quickly talk about them. Private company. In private company, there are minimum 2 members and maximum, now earlier it was 50, now it is 200. Private company can not take, it cannot take money from the market, it cannot sell its shares, it cannot collect money from the market, and there are less statutory requirement. It is suited for a small kind of business, because for large scale business you need a lot of money, and for that you need to offer shares to the public, or shares or debentures, or you need money from financial institutions. So private company has this kind of limitations. Board of directors can be, there are board of directors in private companies also. One person company. This was introduced in 2013 Act. earlier there was only for a company to be incorporated or registered, there had to be minimum 2 members. But now 1-person company can be established, and 1-person company is another form of proprietary concern, but in limited, but in 1-person, sorry, yes, but in 1-person company, it is limited liability, limited to the extent of the share. Public companies are big companies. It can offer share in the market. It can collect money from the market, and there are more stringent requirements. There are prospect and now small companies, holding company, and subsidiary companies. The company who owns more than 20% shares is the holding company. Section 8 company, which is a public. Earlier it was Section 25 of the Companies Act, but of 1957. Now under Section 8 of the Companies Act 2013, for companies can be established for charitable purposes. Government company, which is owned by the government, 51% shares. So these are the main forms of companies. So with this, we wind up our today's presentation. Thank you very much.
Indira Gandhi National Open University, accredited with A++ grade by NAC, provides you a quality education in open and distance learning. School of Performing and Visual Art is offering a wide range